My guest this week is Damien Carrick, the host of the ABC Law Report. Hello, Damien.
G'day, Mark.
Now, thanks for joining us, and I was really excited to see you go on that Oxford Reuters Institute fellowship a couple of years ago, where you were actually looking at privacy and the media. But before we go there, would you mind just explaining how a journalist works in this domain of journalism and the law?
Well, I work on the Law Report, which is the specialist legal current affairs show on ABC Radio National. And I think most people who've done the gig over the years have been legally qualified and worked as lawyers before they came into the media. And that's my background. I worked for a few years as a solicitor before running away to journalism, which is a lot more fun. Not as well paid, but a lot more fun.
Yeah, well, it's a great combination I'm finding myself in my career, Damien. So now this Oxford Fellowship, you took up that fascinating area because there's a long background in the UK to do with media invasions of privacy and how the laws developed there. Just tell us a little bit about the Oxford Fellowship and what was involved and why you chose privacy as the topic.
Well, there's a place called the Reuters Institute for the Study of Journalism at Oxford University, and it's obviously sponsored by Reuters. But one of the organisations which has a long-term relationship with the Reuters Institute is the ABC. And all around the world, people from all around the world sort of converge on this institute to look at current issues around journalism. And each year, the ABC send somebody to look at a current issue around journalism. And they hold a sort of an internal competition to choose that person. And you come up with an idea and a panel of people decide who should go. And I won that competition in 2012, and it was about privacy, which of course was a massive issue back then. You know, the Leveson Inquiry was happening right then and there. We'd had the Convergence Review, we'd had the Finkelstein report, we'd had a Commonwealth issues paper about whether or not we should have a statutory cause of action. So I was very lucky. I went back in this time 2 years ago in sort of April, May, June, July 2012, and I was at Oxford, but often travelled down to London to actually attend the Leveson Inquiry. It was fascinating to be there when, say, Rebecca Brooks gave her evidence. Fascinating time, fascinating issue.
Just in general terms, what is it about the media and privacy, and what's at stake here?
That's a big question. I suppose at the end of the day, what's in the public interest is what is of the public interest, gossip, looking at people's private lives. Is that the same as what's in the public interest? And big question, and what falls on either side of the line is a difficult question to answer clearly. I don't think it's black and white. And I think that's a huge issue for the media. When are you stepping over the line? And we've seen, of course, that in the UK, phone hacking clearly overstepping the line, in many cases overstepping the criminal law line, and we're seeing trials at the moment around that in the UK. But also there's this moral and there's this ethical issue for the media. And there's a question about whether we need to follow our own codes of ethics. But there's also that question about whether or not there should be a statutory cause of action, civil right in the civil courts to sue for a breach of privacy. And that's a big question. And I think the media have a big investment in whether or not that cause of action becomes law here.
Well, you're right. I guess both privacy and free expression are on some sort of spectrum, and different countries, different parts of the world have basically decided that those rights should compete in different ways under the law in different places according to how privacy is valued in those societies. In Australia, it seems that we've had quite a tension here. I guess overall in this area, the media has pretty much won out. In the area of celebrity journalism, though, it seems the whole thing's headed towards more and more celebrity and gossip journalism, which necessitates an invasion of privacy to some extent. How do we rationalise all of this?
Mark, I think it's very difficult because if people make a living out of opening the door into their private lives, should they be able to choose when that door should be closed again? It's a very, very tough issue. And I think when it comes to celebrity journalism, gossip journalism, it's difficult for me to comment because that's not what I have to do on a daily basis. These are not the kinds of ethical issues I need to make myself on a daily basis. But there is a difficulty. If you make your living from opening up your private life, should you be able to close the door when you want to? It's a tricky one. And as you say, people decide things differently in different countries. And I think, as I understand it, the French, at one end of the spectrum, have very kind of tight privacy laws. You've got places like the UK in the middle. And you said before it's a big issue here. It is a big issue here, but by the same token, we haven't had the same egregious breaches of privacy by the media to the extent that we have seen in the UK. And that is perhaps why in the UK you've seen the development of the law far more so than we have seen here in Australia. So it is a serious issue here, but perhaps not as serious as in some other countries.
We've had a few things from time to time. I recall the Finkelstein Inquiry actually had a bit of trouble, I think, finding big examples like in the UK. We've had the bugging of Nicole Kidman's residence. We've had the girl, the victim of the collar bomb crime, who the media stalked out her house and had footage as she was trying to go to school. What else have we had? We've had the ABC itself involved in an intermediate court case where there was an accidental naming of a Jane Doe, a rape victim, and it finished up being a settlement for invasion or a breach of her right to privacy at that intermediate court level. Not a celebrity, of course. So
she was a sexual assault victim, as I remember.
Yes.
And what happened was that there was a prosecution, there was a conviction. She then went on to commence civil litigation against her attacker. And the journalists who are covering that case failed to realise that there's a blanket, very, very clear ban on ever mentioning somebody who has been the victim of a sexual assault. And they named that person, and yes, there was civil litigation, and which I think ultimately resulted in a settlement rather than being appealed. Yeah.
And I'm glad you reinforced all of that, because a lot of the people viewing this video will indeed be students, and if they take into their careers the fact that we never identify a sexual assault victim, then that's something they've learned from today at the very least. And I know that
a very important lesson.
Yeah. Yep. And it's a worthwhile point at which to go into that issue of this proposed reform, which is to do with what they call a serious invasion of privacy, as if there's something less than serious invasions of privacy sometimes, and maybe some of these celebrity invasions are a bit less, going into elements of their private life that they've almost disclosed themselves, whereas our sexual assault victim, here's a very serious invasion. What do you think of that idea of distinguishing the serious from the less serious in a privacy tort?
I think it's important that it should only be a serious invasion of privacy, because, like you say, there's a spectrum, and a lot of people make that they engage with the media about letting the media into their life. So it has to be something extremely serious, like, for instance, say, the Max Mosley case in the UK, which you may remember was the head of Formula One over in the UK. The News of the World, the same people who were involved in the phone hacking a few years later, they basically put hidden video cameras into a sadomasochistic orgy, consensual sadomasochistic orgy with the prostitutes that he was involved with. And the court there said, look, this is a very, very serious invasion of privacy, and there's no real public interest here in exposing this kind of stuff. He wasn't a politician who was banging on about, closing down the sex industry or something like that. It was just a very, very serious invasion of privacy with no corresponding public interest, which would countervail that serious invasion of privacy.
Well, it's interesting you should use that case because there's been and we won't go into all the detail of the different development of the law in the UK, but it has developed markedly since the UK came under that European human rights framework, where privacy is put into competition with free expression as fundamental human rights. Now, we don't have that in Australia. They have it in the US with, the First Amendment, protection of free expression. We don't have free expression as part of any sort of Bill of Rights or a formal constitutional recognition. Does that make a big difference in the development of a statutory tort here in Australia?
It's hard to know when it comes to the media because we haven't had any of the cases. We have had, as I think you pointed out before, we've had a few cases at a lower level, nothing which has reached the High Court, which have been around privacy, but none of them have been around the media. So, for instance, I think there was a case of Giller and Prosopets, which was a Victorian case where nasty couple breakup where the man took videos of his wife, sexually explicit videos of his wife, and then showed them to other people, not broadcast on the media, but show them to friends and family. And there was held, this was really ugly stuff, totally inappropriate, and the court found in favour, awarded damages, I think, to the woman for that. We haven't had similar sorts of cases in the UK where there's a long line of cases around infringements of privacy involving the media. So it's very, very hard to know what the framework will be. We have these other cases which are not about the media, which may form the platform upon which cases involving the media can be brought and succeed, but we're yet to have those cases, which maybe does say something about our media, maybe, I'm not sure. I don't know. I'd like to think so.
Yeah, there's also a question of accessibility, isn't it? I mean, one of the reasons these have been intermediate court decisions would be A, because when the media was involved, perhaps it wasn't in their interests to appeal it to a higher court because they might not want to have seen higher courts just rule on privacy. But also, if there is a tort of privacy, there's that question of accessibility to the courts for ordinary people to be able to pursue this right.
Absolutely, Mark. And if you look at the cases in the UK, a lot of them involve highly paid footballers. That seems to be the big category of people, as well as celebrities, of other descriptions. They are the big group. So you have a whole lot of people, Rio Ferdinand, Ryan Giggs, all sorts of people involved in these sorts of cases. So yes, they're the people who have the ability to use the courts to fight for their rights, to maintain their privacy. And indeed, I think here in Australia, I think a couple of years ago, you had Jeffrey Edelsten and his wife, Bryn. There was some issue about, issues in their private lives, and these are people who I think at the time had a reality TV show called My Bedazzled Life. Now, they were able to go to the courts and seek an injunction, I think on the basis of commercial incompetence for some kind of commercial transaction. Again, it wasn't privacy, but they were using the legal avenues available to them because they had the means to do so. And I think celebrities and people with means will do that. Maybe the rest of us might not be able to. And that's a very important public policy question. Do we want to create another weapon for people with means? On the other hand, do we want to not allow people with a legitimate cause of action or complaint to bring an action against the media? It's a difficult one.
And a lot of people will be left puzzling over that if it's the poor or even the middle class who are left with the less than satisfactory self-regulatory mechanisms, whereas the rich are able to take advantage of a new tort. Damien, I promised you 15 minutes, and it's been that now, and it'll be interesting to see how the Australian government approaches regulation in the near future. Thanks for joining us today.
A great pleasure.